Ladies and gentlemen, welcome indeed. It's time for our panel discussion that we're talking about, and it's time for a topic that we're all looking forward to when we say COVID-19 relief legislation to help companies in distress. Well, after getting some very interesting thoughts from our keynote speakers, let's now move on to our panel discussion, and let me quickly introduce our set of panelists, including our moderator. We have with us Peter Bowden, who's partner with Gilbert+Tobin's Banking and Infrastructure Group, who specializes in front-end restructuring and insolvency. We are also joined by Rishi Hindocha, who's a counsel with Allen and Overy LLP, and in fact, he advises in general banking transactions and distressed debt trading as well. We also have with us Nilang Desai, who's partner with AZB and Partners, and he's someone who has joined AZB in 2013 from White & Case in London, where he had spent nearly 3 years after a total of 4 years in French firm as well. With that, we'll also quickly invite our session moderator. We have thus Ajay Shaw, partner DSK Legal, who in fact has been with DSK Legal for 15 years and is recognized and respected for his expertise in the areas of restructuring and insolvency, energy and infrastructure, project finance, mergers and acquisitions. So there we go. We're about to begin with our panel discussion for all of you, ladies and gentlemen. And I do hope that we'll also get some very interesting set of questions coming in from our delegates, so please use the discuss button. We're going to bring in our speakers on the main screen, so stay with us for just a couple of seconds as I bring them all here on the main screen. So that's right, here we are on the main screen. Our moderator Ajay has also joined in. So welcome indeed, gentlemen. With that, we're about to get the panel discussion started. Delegates, meanwhile, I'm going to request you to please use the discuss button to your right side of the screen in case you have any questions you'd like to direct to our speakers and our panelists. So with that, I'll hand over the proceedings to our session moderator. With that, over to you, sir.
Thank you, Kavya. Good morning, everyone. The topic for this discussion is COVID reliefs and the basic legislative, regulatory, institutional changes which has occurred in order to address the requirement of companies arising out of COVID-19. We have with us Mr. Peter, Rishi, and Nilang, and we'll be touching upon the landscape in terms of what are the changes which has happened in India, and parallelly understand from Peter the changes in Australia, and Rishi can throw some light with respect to Singapore and UK. The intent of the discussion will be to try and focus around the various measures which have been introduced, whether on account of legislative changes, whether on account of policy initiatives taken by the government, or regulatory changes made or initiated by the regulator governing lending institutions, and also in situations where courts have actually come into the picture, like India Supreme Court and NCLT and NCLAT have been pretty active. We'll start with Nilang. So Nilang, it would be helpful if you could just walk us through in terms of the changes which have been there, and what are your views in terms of the effectiveness of these changes, and what do you think is the shortcoming, and how do we address that?
Sure. Thank you, Ajay. It was but natural that it got to feel like a pandemic was going to elicit a response on various counts. And what we've seen in India, and I thought I might highlight it in sort of buckets so that we can then discuss with Peter and Rishi how other jurisdictions have handled each of these topics. What we've seen in India is a reaction from the regulators, from the courts, including the Supreme Court, the government authorities, to give relief on a number of aspects. So to kick off, the RBI came in and gave relief from a cash flow perspective, when it came in and said that banks are entitled to give moratoriums on term loans, relaxations on working capital facilities, and effectively give relief to both corporate and retail users, retail borrowers and corporate borrowers from the cash flow concerns that will arise during COVID. So that was, the first kickoff limb really from the RBI. But that obviously wasn't enough because, to help people on cash flow was not the only solution. So then we had, the government come in with the ordinance and suspend the IBC. And if you like, give structural relief to corporates and prevent these companies which are under stress from being taken into the IBC and being forced into a restructuring. So that was sort of the second limb. Keep in mind that the Supreme Court then jumped in and said, wait a minute, not only are you giving EMI moratoriums, but you need to think a little bit about whether you can charge interest and compound interest on the fact that these EMI payments have not been made. You also should not mark someone as an NPA if they haven't been, marked already as an NPA by, say, August or whatever. So this was, I think, in a sense, the Supreme Court coming in and giving regulatory relief. So we've got cash flow relief, we've been given structural relief, we've been given regulatory relief. The IBBI, the Insolvency and Bankruptcy Board, then came in and said, wait a minute, there's been lockdowns in various states across the country. There's been a national lockdown, a state lockdown. Obviously, ongoing IBC cases are going to have a problem. So there was an exclusion from the ongoing timelines for the period of the lockdown in any states or across the country. So we got some process relief. The most important, actually, in some ways, given that everyone's got the relief, the borrowers and the various stakeholders, was really the banks. Because if you think about it, the banks are really also bearing the brunt of this when everyone goes off on, an EMI moratorium and doesn't want to pay interest and so on. So important for them was, some sort of relief to help them keep their books alive. And that's when the RBI came in, early August and said, I'm going to give you an OTR scheme, which is in some senses a little easier to achieve than the June 7th restructuring scheme, and in other senses more difficult. So here was the lender relief which came in. And then, of course, government has been talking about introducing a pre-pack scheme for medium, small, and micro enterprises to help give banks another restructuring tool. So here are the various buckets we've got in India. Cash flow relief, regulatory relief, structural relief, process relief, and lender relief. And it would be interesting to hear from Peter and Rishi whether, the reliefs that have been given in each of these buckets, how they compare to their jurisdictions, whether their jurisdictions have given less or more or have done these same buckets differently. So just then to touch very quickly on each bucket, in terms of structural relief in the IBC, what we have in India is the IBC suspended initially for 6 months, now 9 months. And when we say suspended, no creditor can take a company into IBC for a default, which happens after 25th March. Why 25th March? The thinking was COVID stress had to be taken into account. How do you define COVID stress? Almost impossible. So I think the marker taken was a national lockdown start date. And said, any default after that, assume it's COVID default, and therefore you cannot start IBC. The funny thing was, even a company which voluntarily wants to go into IBC was prevented from doing so. And, there are commentators out there who've been unclear as to whether that was sensible. That's a discussion maybe for another time, but it'll be helpful to understand from your perspective whether, in your jurisdictions, a company which believes it's had enough and it was already in significant stress coming into COVID and now there's just no hope and wants to go into IBC, are those kind of companies allowed to go in? The other curious thing is if you default during the suspension period of 6 months, 9 months, the law seems to suggest that default can never, ever be the basis of an IBC application. So if you've defaulted in this period, but then immediately after the suspension period ends, you then become completely kosher and pay up all your debt, then the fact that you defaulted then means that you can never be taken into IBC for that debt. I appreciate most, borrowers won't do that, misbehave for 9 months and then behave perfectly for the rest of the term. But what happens for those loans which end during the suspension period? So for those kind of loans which end during the suspension period and have defaulted, you can never take them into IBC. Now, admittedly, there are other recovery reliefs, right? We haven't suspended the ability to enforce security, go to a court to demand, a payment decree and enforce that against the borrower, etc. But the IBC has been pretty effective, and many people have used it not only as an insolvency and restructuring tool, but also as a recovery tool. So not having that forever has been, a curious move. And then, of course, NCLTs and high courts and Supreme Courts, they've all stepped in, with their bleeding heart judgments. In one case, NCLT has said, so what if you defaulted before 25th March and before the suspension period? This looks a little tough for you guys. Why don't you go away and settle? I won't admit you into IBC just yet. Now, maybe that makes sense. But, you can see how across the board in many cases, from regulators to governments to, Supreme Court judges to NCLT judges, everyone's taken a bit of a backseat in terms of putting the pressure on borrowers. I think that was it for me from now. And if I could hand over to Peter and Rishi to, maybe talk a little bit about how their jurisdictions have handled some of these issues.
So Peter, would you want to talk about the Australian regime and what are the changes which you have seen on account of COVID-19?
Sure, Ajay, thank you, and thanks everyone for listening in. Hopefully everyone can hear me okay. So, very interesting time, obviously, across the world. In Australia, we started feeling the full effects of COVID-19 in March of this year. We as a law firm were then experiencing significant increases in volumes of inquiries from corporates and banks around what the impact of COVID-19 was going to be from a legal perspective. Some of the main concerns were around trading whilst insolvent. Under the Australian laws, a director can be personally liable for trading while insolvent. So stepping into a COVID-affected period, we had directors in particular who were particularly concerned about their liability for insolvent trading. So as a result of that, and to address some of the more substantive issues facing corporates, the government stepped in and actually put a moratorium on insolvent trading from mid-March into the end of September. This was a real change in law in Australia and a real change in focus because we have a very punitive insolvent trading regime. So to effectively give directors that free rein and that clear space to trade really stopped insolvencies from happening from that period of time. Effectively what the laws said, and these were temporary laws originally from mid-March until mid-September, were that as long as you were incurring debts in the ordinary course of a business, then you wouldn't be personally liable for those debts. So it was a really immediate and dramatic law to put in place in Australia, and it had the desired effect because directors then had the ability to trade out of their issues and not enter into an immediate insolvency. Together with those laws, the government also effectively increased the time with which a company has to comply with a statutory demand, and that under Australian law is the first step in a winding up process. So a counterparty that needs to wind up another company because they haven't paid their debt will issue a statutory demand. Under Australian law, you have 21 days to comply with that. If you don't comply, then it's a presumption of insolvency under the Corporations Act in Australia. So what the government did was it increased the threshold for which you can issue a statutory demand from $2,000 to $20,000 and increased the time of compliance from 21 days to 6 months. So effectively what that did was during this interim moratorium period, you couldn't wind up another company because they had 6 months to comply with the statutory demand. So that, together with the moratorium on liability for insolvent trading, has meant that we've had very, very few insolvencies over the past 6 months. The government have come out recently and have extended that period of moratorium or those temporary measures until the 31st of December. But they've also come out at the same time and said that they're not going to be extending that any further. So it's an interesting period of time because it means directors have that free rein and the ability to incur debts in the ordinary course until the end of the year without fear of personal liability. They also know that they can't be wound up effectively by third parties during that period of time. But at the end of that period, effectively, we're going back to the conditions from a regulatory or legal landscape that we were in pre-COVID. So what the government has sought to do to address that on a more substantive, permanent basis is introduce new debtor in possession laws. This is very different to the traditional Australian regime, which has always been a creditor in possession regime. So it's a complete contradiction to what we're used to. Interestingly, the laws only apply at a low threshold, relatively similar to what's happening in the UK. In Australia, if the creditor pool is less than $1 million, then the company will be able to access this new SME restructuring regime, which is a debtor in possession model. So it's quite a low threshold. It means that obviously not all companies will be able to access it, but based upon the statistics that the government has in front of them at the time of introducing the laws, they're suggesting that 78% of insolvencies have less than $1 million worth of creditors. So it's based on the US and the UK models of debtor in possession. To the extent that a company has less than $1 million of creditors, they'll be able to rely upon this provision. And it effectively means that the directors remain where they are. They drive the restructure. They will engage a small business restructuring professional to assist with them. They'll develop a restructuring plan. They'll submit it to creditors, and creditors will have effectively 15 business days to vote on whether or not they accept it. And if there's a majority in value voting in favour of the resolution, then that resolution will be passed. So really interesting times in the Australian insolvency landscape. Obviously, we're in the midst of the temporary legislation, which has had a dramatic effect, but we're in for some really interesting times post 31st of December when we have both the stopping of the temporary measures, the introduction of the small business restructuring regime, but otherwise in respect of any entities that have debts greater than $1 million, they'll just have to rely upon our ordinary measures under the insolvency laws. So, yeah, it's going to be interesting to watch, and look forward to hearing from Rishi as well about what's happening in the
UK. Thank you, Peter. Rishi, if you could walk us through the landscape changes in Singapore and UK. And I think what would be interesting to hear also is, what kind of mechanisms are there in place to allow a debtor in possession restructuring, because that seems to be the need of the hour.
Absolutely. Thank you, Ajay and Peter, and hi, everyone. Thank you for listening in. It's very interesting to kind of hear the measures that these jurisdictions have adopted, because obviously UK and Singapore, like Australia and India, are common law-based jurisdictions. So there's some similarities across what each of the jurisdictions have introduced in terms of economic stimulus and relief measures, but there are also quite a few differences. And if you look at, it's interesting that Nilang mentioned the suspension of the IBC process as well, because that to me seemed like it's taking away a process that might be quite useful during this time. And if you look at the UK and Singapore and how they've reacted in comparison, I think there's been some differences. Instead of kind of suspending processes, actually they've introduced new processes and tools into their framework. So if you take a step back and look at the UK, it already had a very kind of highly flexible corporate restructuring and insolvency environment. And because of the prevalence of English law governed financings, you'd have a number of foreign companies to restructure their debt using English courts and English processes. But it's reacted, it's completely revamped its restructuring and insolvency framework, partly due to COVID, but it was already looking at kind of how it could make the framework better. So it introduced, I think, in the space of 6 weeks, new legislation called the Corporate Insolvency and Governance Act. And that act did two things. On the one hand, it implemented some temporary relief measures for companies. And by way of example, similar to Australia, it introduced a temporary suspension on statutory demands and winding up petitions, where any company defaulted on its debt due to COVID-19. And then, Nilang, you mentioned that India is looking at that as well. And it's quite interesting. I mean, that protection measure or that suspension has been extended. It was till September. Now it's been extended till December. The idea being that companies are given the time to kind of work through this pandemic and hopefully come out at the other end. But it's also interesting to see how you would define, defaults due to COVID-19. If the company was already struggling before the pandemic, are they using this as cover to continue? And should they be using this as cover? So, there's no clear kind of definition of what is a default due to COVID-19. But it does give that bubble of space to companies to continue to operate. The second temporary relief measure that was introduced is the suspension of directors' liabilities for wrongful trading, and as Peter mentioned, it's a similar setup in the UK, and I think India has a wrongful trading liability laws as well. But the idea is obviously if a director of an English company can be liable for wrongful trading where they've continued to trade and there's no reasonable prospect of avoiding going into insolvency. So that could, if they do that, that could lead to personal liability for directors and even disqualification. So the proposition by suspending the wrongful trading liabilities is to give the directors the space to continue to trade during COVID-19 without the fear of that personal liability. Now, interestingly, what the UK has done recently is that suspension was in place until September, and that suspension has not been extended till the end of the year. So whilst you've got a suspension on winding up positions and statutory demands against companies till the end of the year, the suspension on directors' wrongful liability laws are now passed. So I think what the UK is saying to directors is, you've had a period now where we've protected you, we've given you this bubble to trade. Now you can continue to trade, but it's up to you, directors, to make the call as to whether you think it's right to continue to trade or whether you should file a winding up petition. So we're seeing that transition now out of the pandemic where companies have had the initial opportunity, the initial bubble to say, work your problems out. Yes, this pandemic has come out of the blue and you need time, but now you should be in a position to know whether actually you have a viable business or not and whether you should be filing for winding up. So it's quite an interesting tactic that the UK has adopted. The kind of second element of the Act that came in is a more permanent feature to the insolvency and restructuring landscape. So it introduced a new standalone moratorium provision that companies can apply for. And on application by a company for this moratorium, companies get an initial period of 20 business days in order to find a restructuring solution without the fear of kind of enforcement and petitions against that company. That moratorium can be extended for another 20 business days, and then upon further application and by agreement with the creditors. So that it's a quite a useful permanent feature that has now been introduced in the framework. The second thing that it did fundamentally is introduce a new restructuring plan. And the restructuring plan is very much like a scheme of arrangement process. It's a court-led process, a court-sanctioned process, which allows a company to agree a compromise with the majority of its creditors and then cram that, effectively force that restructuring plan on the minority dissenting creditors. So it's quite a useful tool to use. The difference between the restructuring plan and the scheme is in a scheme of arrangement, you need the majority in number and 75% by value of each class of creditor to approve that scheme. With a restructuring plan, provided you've got one class of creditor that approves 75% by value, there's no numerosity requirement, you can force that restructuring on dissenting classes of creditors. So it's an even more powerful tool than the scheme of arrangement. It's more flexible, more powerful. You couple that with the standalone moratorium, and you've got a really good, useful restructuring tool that companies can use in these times to restructure. Now, the framework in the UK wasn't broken pre-COVID. It worked really well. But it's interesting that the UK government thought, what more do we need to do? What more tools do we need to put into place in order to make this more viable for businesses to continue to operate and to restructure? So it's taken quite a different approach. Instead of suspending processes, it's actually added to its tools. And then just kind of briefly touching on Singapore, Singapore pre-COVID had been positioning itself as a debt restructuring hub. So, it's built up this framework of restructuring tools, powerful tools and processes in order to allow companies to restructure. And it's actually inviting foreign companies to use Singapore as a hub to restructure. It's got the right judicial system. It's got very experienced judges, just like Australia and India. And so, these judges are experienced in handling these restructuring matters. So the courts are open for business. So what Singapore did is it introduced temporary relief measures. So, but they tend to be quite limited in scope in terms of the measures that they've introduced. And on the whole, they've adopted a laissez-faire approach. Let the market work itself out. Right? The relief measures are mainly, they've increased the statutory demand thresholds to $100,000 from $10,000. They've also increased the time to meet a statutory demand, similar to Australia, from 3 weeks to 6 months. So it's given that initial period for companies to try and work itself out. But on the whole, the relief measures have largely targeted small and medium enterprises. So small and medium enterprises can opt to defer their principal payments until the end of the year. They're also granted various loan relief measures, and they have access to grants and government loans and schemes. So they can access liquidity, but they can also defer principal payments on their existing debts. But this targeted relief is very much for small and medium enterprises. Large companies still have to deal with their own problems. So one of the recent tools that the Parliament is looking at is to introduce a new small and medium enterprises restructuring and winding up program. So basically, it's a cheaper, quicker way for small and medium companies to restructure their liabilities. And it requires 66% by value of their creditors to approve the plan. So it's a lower threshold than a scheme, which is 75% by value. And it's cheaper, it's faster, and it's more efficient for small companies just to implement a restructuring. So again, it's targeting the small and medium companies. It's not really trying to protect the big companies. And the approach that's largely been taken in Singapore, as with the UK, is large companies, you know what you have to do. If you've got a problem, directors, you need to deal with it. You need to restructure. We've got all the framework in place. We've got the tools in place. You need to take responsibility and decide whether this company deserves to continue to operate or whether the problems are so significant that either it needs to restructure or it needs to be liquidated. So that's broadly kind of the approaches that Singapore and the UK have taken.
Thank you, Rishi. Just to add, I think India also just introduced a change whereby the limits was increased from $1,300 to almost $140,000 to invoke insolvency. What would be interesting, Nilang, to understand your views that debtor in possession is a requirement in this hour where the company should be restructured. The only framework which people seem to be relying on is more the August 6th circular. It is interesting that Rishi touched upon the scheme which under the Indian Companies Act also we have provisions under section 230 to 232 where you can actually have a restructuring scheme amongst the creditors and enforce it on the dissenting creditors by supermajority, which is 75%. Do you think this scheme may be an option and August 6 is really serving its purpose in context of a restructuring with debtor in possession, considering one of the key element, which is moratorium, which otherwise is available under the IBC, technically does not get available or is not available under these situations, other than for a forbearance agreement, which is purely contractual?
No, agreed. I think, a couple of points, but just before we jump onto that, Peter and Rishi, India has also suspended director liability for wrongful trading during this period. So I think we've hit that one as well. And obviously that's very important. But sorry, coming back to what you were saying, Ajay, August 6th circular, I think it's early days. There's been a lot of commentary out there about how it's far too strict and it's not really going to help banks restructure most of their cases. Whether that's the case or not, we will find out. It certainly is strict, and the RBI has always been sort of, I think, managing that balance between helping out those borrowers who are suffering COVID stress, but not giving a free run to people who are otherwise already in default and already stressed, and taking advantage of the fact that, there's COVID stress. I mean, only a couple of months ago, I was in court because, an Indian infrastructure provider, which had been in default for a couple of years before COVID, had a default. Our lenders were getting tough. They had an English law facility, an English law exclusive jurisdiction, but they landed up in an Indian high court and said, "Oh, wait a minute, we are an infrastructure provider, and there's lots of COVID stress in us. Help us." And we just stood there in court saying, "How is this court even listening to this argument? It's exclusive English court jurisdiction. It's an English law facility, and you've been in default 2 years before COVID." But courts were sentimental. So I think there will always be people who want to take advantage of a situation. And I think the RBI has been very conscious of that, and which is why they've delineated the 6th August circular so much to say only COVID stress, and this is the narrow way in which we define COVID stress. Is it too narrow? We'll find out. I'm sure the banks are giving feedback to the RBI on that point. But coming back to your other issue about debtor in possession and the scheme, again, right? I mean, there is baggage, as there always is in India, and there has been a mindset that companies which come into stress have come into stress because the owner manager or the promoters have siphoned, have cheated, have been unfair, have been unethical, etc. And it's some cases it's right, in some cases it isn't. But for better or for worse, that is the mindset in many cases, that if you've come to this level of stress after so long, you must have done something wrong. And to then allow you to continue to possess the company while we're trying to impose a restructuring on you, and therefore just allow you to siphon off even more assets and leave a completely empty shell, just seems like madness, right? I mean, what was the recovery percentage under our erstwhile creditor in possession creditor schemes, restructuring schemes? Pennies, single-digit pennies, right? For whatever it's worth, SR Steel took a lot of time, but the recovery was incredible. And there's so many other cases where there's been better recovery. Equally, there have been cases where the recovery's been poor, but I think at least now we have a tool which allows us to limit the amount of damage at a point in time for those kind of promoters where, they've been in default and they have caused the default and, they've been bad promoters, so to speak. And to be fair, we do have the ability, even under the IBC, for the promoters to come back. There's a common misconception that if you go into IBC, the promoters or the owner managers are out. That's not the case, right? It's only if you've defaulted and you've defaulted for more than 15 months that you're kicked out of your company. So you have a 15-month window in which to restructure your company and get your company back. And yes, it is creditor in possession, but it's creditor in possession for a very short period. And frankly, if you see the threat coming, restructure before that. I think that comes to your point, Ajay, which is how do you restructure outside the IBC? And the only real available tools we have besides the one-time restructuring circular, which only really applies to banks and NBFCs and Indian financial institutions, and won't help restructure other kinds of debt, whether it's mutual fund debt or foreign debt holders. What do you do to restructure those? And yes, you have the scheme. But I think the problem we have with the scheme is two. One, you already identified, right? There's no moratorium. So while you have a scheme ongoing, you can have people filing all other sorts of actions. Now, I suspect, if the scheme was used more often, Ajay, maybe courts will develop case law to say, while we are pushing through a scheme, suspend other actions, and maybe there'll be some committee between the High Court where the scheme is going on, an NCLT or a DRT where other actions are filed. And, those people say, no, but the scheme is going on, so let's just give the scheme a chance. There'll be sort of maybe a case law-driven moratorium, perhaps. But most importantly, I think the problem we have with the scheme is it's a class-driven process, right? I think Rishi was mentioning that in the UK, they have this concept of one class which agrees with the restructuring, forcing the restructuring on other classes. I mean, that's really interesting because that's something we don't have in our scheme. And that's where we struggle. In a lot of these cases, secures will want to keep most of the money. The unsecures will go, no, wait a minute, we have leverage here, and I'm not approving the scheme. And what do you do? And it takes so long for the scheme to go through, and it's creditor in possession, that a lender is thinking, why, if I was in the right mind, would I use the concept where there's no moratorium, where I have to shout out to guys who are completely out of the money, and it's going to take so long while the creditor is in possession that I'm going to go into an empty shell by the time I actually get there. I think that's what we're facing when we look at a scheme in terms of hurdle.
That's interesting. Rishi, you want to throw some light in context of, uh, clients which are looking at India and in terms of how they are addressing their debt which they have locally taken in India. What is the mechanisms which they are kind of contemplating or envisaging?
Yeah, sure. I mean, I think the kind of suspension of the IBC was a little bit of a shock to some clients. I think those clients that are looking at India, that already have positions in India, have been there for a while, have set up structures in place, FPIs, through ARCs, etc. They know the landscape. I think with COVID, you've got the added uncertainty of how things are going to play out. And I think it's the uncertainty that has driven a lot of the questions that we see coming through in terms of what do we do now? How do we best structure? And some of the structuring that we see now tries to, we do a lot of margin loan financings where the structures are offshore in Malaysia, etc. But the shares are, listed companies in India. And we're seeing, in that sense, margin calls being made. We're seeing those kind of situations resolve itself. And I think that's the kind of one area that we are seeing the kind of enforcement measures being taken and margin calls being made and perhaps lenders kind of losing patience because of the share price volatility. People are actually now moving to take action. But on the whole, in terms of, creditor action, what can creditors do in these times? If you can't get to the asset because of lockdown measures, if you can't get to the asset because of the government relief measures, then why enforce right now? Why not wait until you can see how the situation plays out? And then there may be some light at the end of the tunnel. So I think on the whole, we're seeing a lot of kind of wait and see approaches outside of margin financing. So I think we're seeing the kind of people are being a bit more patient. Everybody is understanding and supportive. But as Peter said, once these kind of transitional relief measures fall away, the question really is, are we going to see that tsunami of liquidations and enforcement measures being taken? Or will people find a transitional way out of this and try and work things through? And that, I think, is a difficult question to answer.
Peter, what will be interesting to hear from you is that most companies, even if they have not defaulted, there is going to be an impact on cash flow going forward for certain businesses, specifically hospitality, tourism, aviation. Now, in this situation, you will clearly have an unsustainable portion of the debt. So, what has been the reaction of lenders in the Australian jurisdiction in terms of dealing with such unsustainable portion? Are they voluntarily restructuring? Are they taking measures to address that?
Yeah, look, it's an interesting question, and it comes off the back of a royal commission that we had in Australia into the banking industry. So the banking industry in Australia faced significant criticisms in terms of the way in which they approach distressed lenders, to be perfectly honest. So the banks, and we've got sort of 4 domestic banks in Australia, obviously lots of international banks, but the domestic banks dominate the market. They've been under increasing pressure over the last couple of years after the Royal Commission to do the right thing and look after their customers. One of the interesting things that happened was that the government introduced responsible lending laws. And what that did was that changed the onus from the borrower having to ensure that they were capable of servicing the loan to the lender. So borrowers had no real, requirement to ensure that they could service loans. All of that pressure went on the lenders. But what happened during COVID was that just completely choked the whole credit market because lenders don't want to lend money to anyone at the moment because of that onus. So the government actually scrapped those laws, which the banks were very happy about, as you can appreciate. So there's a bit of push and pull at the moment with the banks and the government on the regulatory side because banks are still trying to make up ground from when they were very heavily criticised through the Royal Commission. But now, on the basis that the government recognises that the economy needs banks for liquidity, they've softened some of those restrictive laws. So I guess to answer your question, there's significant government and society pressure on banks to ensure that there's liquidity in the market. But at the same time, banks are going to reach a bit of a tipping point, I think, next year, in particular, when the indulgences that they've been given their borrowers come to a point where they're no longer sustainable. So I think the government has relied on banks and landlords, for example, to give liquidity and to give some relief to borrowers. But that's probably going to end next year. And to use the sort of phrase that we hear often, which is the banks are going to have to pick winners and losers. And I think ultimately that's going to end up in an enforcement type scenario. In our market, we don't see many bank-led enforcements, but often banks sort of get to a point where they put so much pressure on the companies that the companies appoint administrators or their own insolvency practitioners to drive the restructure. So banks have been very open, very accommodating, but I think those pressures are going to come to a real critical point towards the end of the year, and they're going to stop being potentially as generous as they have been.
I think we've reached the end of our schedule. So unless anybody wants to make any closing remark or would want to add something, then we can pass it on to the organizers. Kavya, over to you.
All right, then. Thank you so much, Ajay. Thank you indeed to all of our panelists as well. It seemed like a very fruitful discussion, and we managed to gather some very interesting insights there. Thank you so much again for joining us. Once again, delegates, I would also urge you all to keep those questions coming. I'm sure it's a virtual platform, so that exchange of energy and that exchange of questions is not happening as much, but I'm going to urge you all to do that for the sessions henceforth. But meanwhile, thank you so much for your time, gentlemen. Thank you so much for joining us at the Insolvency Summit and sharing your thoughts. Thank you once again. I'm going to humbly request you to please click the exit panel so that you can exit the main screen and maybe carry forward the discussion with your fellow panelists. Thank you once again for joining.
Thank you.